The Department of Education has begun sending approval for relief to student loan forgiveness applicants. This comes after the Biden administration asked the Supreme Court to lift a lower court ruling that blocked the loan relief program. Biden has not said what relief it could provide to loan borrowers if the courts rule against the program.
Joining us now to discuss is executive editor of the American Prospect, David Dayen. Welcome, David.
Thanks.
So, how does it come into play if there is an adverse court ruling? If we're at the phase where the government is notifying people that they could qualify for this forgiveness, I guess if the forgiveness is actually given, it's going to be tough to roll back. Maybe the federal government knows that. What exactly is the timeline here?
Yeah, I think the mentality is to act quickly. If there is clearance, all of this is ready. Millions of loan cancellations are ready to go the moment that the courts clear this program. And of course, at this point, that's probably going to have to be through a Supreme Court ruling, or at least the Supreme Court saying, we decline to hear the case. That's going to be the final resolution here. And I think it's generally smart of the Biden administration to get ready for that eventuality.
David, this logic that the Biden administration needs to be able to act quickly lest there be some other efforts to obstruct legally is exactly the logic that the debt collective advocates were putting out there prior to all of this, knowing that these legal challenges were going to come down the pike. And the question they were asking is, why did the Biden administration, anticipating this very eventuality, not just cancel student debt immediately? Immediately could have been a day one policy. And then to the extent that there needed to be some redistributional consequences, you feel like rich people who don't need their debt canceled get a windfall, simply tax it on the back end. Now, it feels a little like they're they're validating that theory by saying we're going to be poised and ready to forgive the debt forgiveness as soon as there's clearance. But what is the likelihood that they actually get clearance? I've talked to a legal expert, Jed Fordham at Fordham Law, who thinks that in a non-ideological way, this could be a 9-0 decision against the Biden policy in the Supreme Court, simply because of the authority that he used for his executive hook, that being the COVID relief, the HEROES Act, and saying this is a COVID era policy, which is something that the Supreme Court has already said it doesn't really take very kindly to, as it invalidated the eviction moratorium and some of the other COVID era policies. So what is the likelihood here that people are going to see relief?
Well, the only thing that has been adjudicated at this point is the issue of standing, right? Standing means that you have actually had injury, you've been harmed, and you're able to sue in these cases. And my read of the two cases that have, been given standing here is that they're effectively lawless. In one case, you have the Mohela, which is a student loan servicer, which the injury assumed here is that, by canceling debt, you reduce the amount of loans that they have available and therefore the revenue that they have. Mohela, in a letter to Representative Cori Bush, said they are not part of that lawsuit. The Attorney General of the state of Missouri made them a plaintiff on their behalf without telling them. And the Fifth Circuit, who adjudicated that, said, okay, yeah, so Mohela's a plaintiff. They didn't make any of the other states who were in that lawsuit a plaintiff. They said, as long as we get one withstanding, then this case is valid. And they just went ahead and said, okay, Mohela's a plaintiff, even though they said publicly that they're not. So the other case, which is with a district court judge, said that there's two. It's on the lawsuit is on behalf of two students who sued because they're not getting the full value, $20,000 that others are getting, and they said that because they didn't get a notice and comment period to argue for their side of the case, that they have standing to sue, even though later in that very same lawsuit, the judge said this particular authority that the Justice Department is using, or that the Education Department is using, doesn't require a notice and comment period. So these are ridiculous justifications for standing, and they should not hold up in a court that follows the law. Now, are there other situations where you have standing that you would get to the point that you're talking about, that Judge Sugarman has talked about, where the HEROES Act may be not a great authority that you use, especially when there are other authorities available, like the Higher Education Act of 1965? Maybe, but so far, there have been a lot of cases, and nobody has shown standing. Nobody has shown injury and the ability to legally sue here, except for these two edge cases that I talked about that are seemingly absurd if you look at them on the face of the law. So,
well, I mean, you say they're absurd, but they were persuasive. I mean, so far to the Fifth Circuit. There are a lot of people who find absurd the idea that the federal government has the authority to do this, right? I mean, there's plenty of arguments for the absurdities of this whole situation, which is not being done by the process of passing a law that says we're changing the student loan, kind of regime.
You can draw your own conclusions. I gave you the facts of what is being laid out and what is being argued in these cases. And the fact that you have a plaintiff that has been dragooned into a lawsuit when they said they're not a party to the case, and then you have another lawsuit where the plaintiff said, I didn't get the chance to comment, even though they under the law admitted by the judge there is no notice and comment period. I think is ridiculous. I think personally it's absurd. Yeah, you may have a theory about, but that's just my read of the way these cases are going.
I think the counter argument is that if it's been accepted by this Eighth Circuit Court and this Texas court as legally flimsy as people might think that those decisions are, ultimately, this is the court that we have. People have made their commentary about the nature of the judges, whether they're biased, whether they're just advancing their own conservative ideology. But that's the lay of the land. And so the question is, given that this is where we are and that there has been even this level of approval, this level of success by these litigants who have been forum shopping. I mean, this is the game. The whole point is that they've been seeking ideologically friendly courts across the country and have found them now, that there is some risk that the policy would actually not be able to go through.
I think that the Supreme Court, there's a better chance of them dealing with the merits of the case than dealing with these standing issues, which seem, a little out there. However, they have to get through standing before you can get to the merits. So, it's a good question. We're definitely going to see the Supreme Court argue this. And you have 6 conservative justices on the Supreme Court that are uncomfortable with, under the major questions doctrine and all these other things that they've put together. We saw the case with the EPA. They seem uncomfortable with certain impositions of executive power. So, yes, is there a possibility that this is not going to go through? Absolutely.
Well, thank you, David. We'll definitely continue to follow this. Those emails hit people's inboxes. They're wondering if this means that there's something that's going to happen. Obviously, a lot of people turned out in midterms, young voters in particular, in part because of the carrot that's being dangled of student debt relief. So we'll be tracking this one closely. Thanks again, David, for joining us.
All right. Thanks a lot.
We'll have more Rising for you right after this.